Government Business Notice Number 2, standing in the name of Mr Burgoyne to present the Northern Territory Aboriginal Sacred Sites Legislation Amendment Bill 2025, Serial 23.
Minister.
Madam Speaker, I present a bill titled Northern Territory Aboriginal Sacred Sites Legislation Amendment Bill 2025, Serial 23, and table the explanatory statement. Madam Speaker, I move the bill be read a first time. Madam Speaker, I present a bill entitled the Northern Territory Aboriginal Sacred Sites Legislation Amendment Bill 2025. One of the first acts passed by the Legislative Assembly of the Northern Territory following self-government in 1978 was the Aboriginal Sacred Sites Act 1978. In the mid-1980s, the Act was a subject of significant review, resulting in the current version of the Northern Territory Aboriginal Sacred Sites Act 1989. The Act establishes the Aboriginal Areas Protection Authority and provides the framework for the registration and protection of sacred sites in the Northern Territory. The purpose of the Act is reflected in its long title, which states the Act's intended purpose is to effect a practical balance between the recognised need to preserve and enhance Aboriginal culture tradition in relation to certain land in the Territory and the aspirations of Aboriginal and all other peoples of the Territory for their economic, cultural and social advancement. Since the Act commenced operation, there have been considerable economic, political and social developments in the Northern Territory. There are three main amendments addressed in this bill. Firstly, the bill formalises the composition of the members of the authority. The majority of the authorities, 10 out of 12, are Aboriginal members, nominated by the land councils to ensure strong representation of traditional owners. It has been long-standing practice that the two remaining members are nominated by the Minister. The Minister's ability to nominate two members provides a mechanism to introduce perspectives that reflect broader policy objectives, development, heritage and governance considerations. This balance is essential to ensure that decisions made by the authority take into account a wider range of interests, including economic and social factors. Accordingly, Section 6 is updated by categorising the authority members into two groups: Aboriginal members nominated by the land councils and members nominated by the Minister. The revised Section 7-3 allows the Administrator to terminate the appointment of an Aboriginal member on limited grounds of incompetent or misbehaviour. Additionally, Section 7.3a and 7.3b are inserted to enable the Minister, at his or her discretion, to recommend in writing to the Administrator for the termination of a member who was appointed on the Minister's nomination. These provisions allow for broader removal powers which reflect that such persons are the Minister's own nominees. Once the Minister makes this recommendation, the Administrator may remove the member from their position. The power to terminate the Minister's nominated members allows for action at the Minister's discretion, including but not limited to where a member is not performing effectively, has a conflict of interest or is acting contrary to the best interests of the authority. This will ensure that the authority remains functional, credible and responsive to evolving policy and community needs. The second key amendment of the bill is to improve process efficiencies in the transferability of an authority certificate and minimise administrative burden on proponents and the authority by allowing additional parties to be recorded on an existing authority certificate. Currently, the Act does not provide a mechanism for transferring an authority certificate from one proponent to another. Authority certificates are limited to the original applicant for the specific works identified in the certificate. For example, Madam Speaker, if a proponent applies for an authority certificate during the early stages of development, the application will be lodged under their entity name. However, once the authority certificate is issued, it cannot be used by another party if the development is later sold to a new developer. As a result, the new proponent must submit a fresh application for an authority certificate, even if the proposed works remain unchanged. This requires the authority to repeat the approval process, including further negotiations with custodians. The lack of transferability creates several challenges. It leads to unnecessary duplication of consultation and approval processes. increasing administrative burdens for both proponents and the authority. The new Section 24A establishes a mechanism for transferring an authority certificate where prior consultations with custodians have already been conducted for the same area of land where an authority certificate has previously been issued. This is a process whereby a person known as a transferee, with the consent of the holder of an existing authority certificate, may apply to the authority for the existing authority certificate to be transferred to the transferee. The application must be in the form approved by the authority and include the required fee. After receiving the application, the authority must issue a new authority certificate to the transferee. The new authority certificate must cover the same land and work or use of the land as the existing authority certificate and have the same conditions. When the new authority certificate is issued, the existing authority certificate is automatically cancelled. It should be noted that these transfers are administrative in nature only. Previous considerations undertaken by the authority or the minister prior to the issuance of the existing authority certificate would have considered wishes of Aboriginal people relating to the extent to which the sacred site should be protected and taken them into account as required by Section 42 of the Act. With these transfers, there will be no changes to the original protections, limitations or controls put on the land to protect the sacred site. Noting the territory is a creation of the Commonwealth Parliament. The Commonwealth Aboriginal Land Rights Act, Northern Territory 1976, operates to require that laws concerning sacred sites in the Northern Territory relevantly must provide a mechanism which, by the wishes of Aboriginal people, properly interpreted as the relevant custodians, are taken into account in determining the extent to which those sites are protected. This new provision is consistent with the requirements of the Aboriginal Lands Rights Act, Northern Territory 1976. As it does not seek to change any of the protections initially imposed, which would have considered the wishes of the relevant custodians regarding the extent to which a sacred sites are protected. Any conditions that were imposed at the time will carry over to the new party to which an authority certificate is subsequently transferred, ensuring the continuity. Sorry, Madam Speaker, I'll say that again. Ensuring the continuing protection. In long-term, large-scale development projects, it is common for multiple entities to undertake work over different stages of the project. Under the current Act, each entity must apply for its own authority certificate, even if the proposed works and land area remain unchanged. The new Section 24B introduces a mechanism allowing the holder of an existing authority certificate to apply for additional individuals or groups to be listed as recorded parties. These recorded parties could include specific individuals or broader groups, such as those working on or making use of the land covered by an authority certificate. An application to add recorded parties must be submitted in the form approved by the authority and accompanied by the required fee. Upon receiving the application, the authority must issue a new authority certificate that includes the additional recorded parties. The new authority certificate must cover the same land and works or use of the land as the original authority certificate and be subject to the same conditions. This includes, importantly, any conditions that were originally imposed, taking into account the wishes of the relevant custodians about the extent to which the sites be protected. Once issued, the new authority certificate automatically replaces and cancels the existing one, but protections will be provided from prosecution for conduct that may have occurred under the previous certificate. This process streamlines regulatory requirements for long-term projects involving multiple entities, reducing duplication and ensuring continuity while maintaining the integrity of the authority's oversight. Madam Speaker, another key amendment in this bill is the introduction of Part IVA, which establishes a framework for the authority to enter into enforceable undertakings in relation to an alleged contravention of the Act or the terms of conditions of an authority certificate. The provisions are modelled on Part VA, Division 2 of the Petroleum Act 1984. Enforceable undertakings provide an alternative to criminal or civil enforcement with the aim of achieving better compliance outcomes while reducing the burden of formal legal proceedings. These undertakings are common in many modern environmental and development legislative regimes. They provide a useful tool for the authority to continue to ensure rigorous protections of sacred sites in the Northern Territory and ensure they have increased powers to ensure remediation occurs where there are any issues. An enforceable undertaking is a binding commitment made by a person in relation to an alleged contravention. It allows the authority to set out specific terms and conditions to ensure compliance with the Act or a term or condition of an authority certificate, which may include a requirement for public notice of the breach and any remedial actions undertaken. To ensure accountability, these undertakings must include clear timeframes for compliance and a method for monitoring processes and a method for monitoring progress, Madam Speaker. Importantly, negotiations surrounding any undertaking do not compromise the legal rights of any party. And if discussions fail, neither party can use what was said during negotiations against the other in future proceedings. Before accepting an undertaking, the authority must consider a range of factors, including the seriousness of the alleged breach, the maximum penalty that could apply, the public interest and the potential benefits of resolving the matter through this alternative mechanism. To ensure transparency, undertakings must be in writing, signed and dated by both parties, and published along with the reasons for acceptance. To uphold the integrity of the enforcement process, Madam Speaker, the bill also introduces mechanisms to ensure compliance with enforceable undertakings. If a party fails to comply, the authority may seek enforcement through the Supreme Court. The court will have the power to impose penalties, recover costs incurred by the authority, order compensation for affected parties, or revoke the undertaking entirely. Additionally, if a person does not comply with an enforcement order, the authority may take necessary steps to carry out the required actions and recover associated costs. The bill also provides flexibility by allowing an enforceable undertaking to be modified or withdrawn with an authority's consent. In the interest of transparency, any variation or withdrawal of an undertaking must be publicly disclosed, along with the reasons for the decision. Further, to incentivise compliance, a person who enters into an enforceable undertaking cannot be subject to criminal proceedings for the alleged contravention while the undertaking remains in effect or after it has been fully discharged. However, if an undertaking is breached, legal proceedings may resume. Criminal prosecution will not be pursued against the person who enters into an enforceable undertaking where the authority is satisfied that all requirements of the undertaking have been met. This reform enhances regulatory compliance while ensuring a fair, efficient and effective resolution of breaches. It provides a more constructive approach to enforcement, reducing unnecessary litigation while maintaining the integrity of the regulatory framework. I am pleased to commend this bill to honourable members and table a copy of the explanatory statement.
Honourable members, I advise of the presence in the gallery of Year 5 and 6 students from Waggaman Primary School accompanied by their teachers. Welcome to Parliament House. The question is that the bill be read a first time. Those of that opinion say aye, to the contrary no. Aye. I think the ayes have it. The clerk.
A bill for an act to amend the Northern Territory Aboriginal Sacred Sites Act 1989 and the Northern Territory Aboriginal Sacred Sites Regulations 2004.
Minister.
Madam Speaker, I move that the bill be referred to the Legislative Scrutiny Committee for a report by 7th of May 2025.